Indian news ma wakɔ aba assign de ba wɔn kasa fidie so bio. Na maka trust before anything else na just our share na ebiem nso kwa na wo subscribe to your channel no. What's the political news there? Never governance. We catch you sa pan put to forma yet. Na pan to forma yet there. Ani na nsɛm foforɔ bi nso asan esi. Benim sɛ wo de nsɛm ade ba nyina na ya na ya wo tɛ na ya wo hwɛ na ya wo fɛ nso so. Nti no nsɛm foforɔ bi asi a India news yan so pan ye to for me baby ati nyina chi no yensa atumi aka bi na yaso anso atimi atisa ensemi bi yentie nsem member sisi a na mpanifo mpo se kakom no ye che no koku enum de ba before that no subscribe to your channel no sabeka all other news fa politics one de opesa wotie no ho etie ba ebe baby asusu anso person de body no fa na de asie bia no so fa comment anso to ase ne yenkenkan informaw de ready na emeko yentie nsem member sisi a utie no fa comment to ase ba be mfa nchemu no nso ento aso yentie mra
enra minority ekobusa attorney general say aden na bail conditions 800 million ye kote so es 600 million esibe ye we ya enra bust former CEO ni bail conditions 60 million ye kote so 30 million edo so dodo na so mo dragi attorney general eba parliament through an urgent question or by answer question. So 3 issues and I'm on the breaking news of the ECOWAS court. City caption is say ECOWAS court rejects Torkono's request to stop probe committee. Oma rejected. The Deputy Attorney General Justice Sham saying the breaking news. So me didn't bro exclusively on the critical analysis. In July, Anna Madam get to talk on the article 146 process na start here, you know. Or call Ghana court na ntentemna no call ECOWAS court. Permit checks ECOWAS court no e Nigeria. Ghana itimi ko ho because you are part of the ECOWAS member state of countries. In the court Ghana need be itimi call to seek reliefs on certain issues. Now occur you know people say what were the reliefs she was seeking? One, the reliefs occur na yet 10 of them. One, or say a declaration that the suspension of the appellant, that is Justice CJ Torkono, as Chief Justice of the Republic of Ghana by President of the Respondent, that's President Mahama, on 22nd April 2025, violated the applicant's human right to a fair hearing guaranteed by Article 7 of the African Charter on Human Rights. Or say a declaration that the panel instituted by Ghana to investigate and determine the allegations of misconduct against the applicant was not constituted to guarantee its independence and impartiality, and as such has violated the applicant's human right to a fair hearing guaranteed by Article 7 of the Human Rights Charter. First and two, ni say process in edi na di na enye kwan papa so. Two no say committee ni ete nipa na ebom di so mo betena so no saa de na eye ni na enye kwan papa ono no e be serve ni interest as Chief Justice e breach the human rights which is guaranteed by the African Charter on Human Rights, Human and People's Rights. Which what mean quote constitution because African ECOWAS konya Ghana constitution on bedjuma the Africa Charter no and a bedjuma. Or say a declaration that the purported suspension of the applicant as the Chief Justice of the Republic of Ghana by the President of the Respondent stated on 22 April 2025, that's 22nd April 2025, constituted a violation of a human right to fair, equitable, and satisfactory condition of work guaranteed by Article 15 of the Africa Charter on Human and People. Say now. Process na yedi yi na di na enye ekwan papa say yedi yi na di na enye say suspend no na e breaching human rights esanye fair enye satisfactory process ni bibia. So basically they now will seek, and let me jump some of the reliefs na ma say 7 no an order ma me nko bia na ye order bia na order say court na nya na that is more because when the reliefs na the reliefs in nature say you breaching human rights process na nya fair process no enye transparent anyway that yenko order from 6 no say an order to the respondent republic, that is Ghana, to act immediately to prescribe the rules of procedure to govern the investigation of allegation of misconduct against the Chief Justice of the Republic of Ghana in conformity with the right to a fair hearing guaranteed by the Constitution of Ghana and the African Charter on Human Rights, Human and People's Rights. An order directing the respondent to lift the suspension immediately and restore the applicant to full office until the conclusion of the fair constitutional processes. An order restraining the respondent from continuing with the purported inquiry for the removal of the applicant as the Chief Justice of the Republic of Ghana in its current form until it confirmed to fair hearing guarantees. An order of 10 million as compensation for moral and reputational damage suffered by the applicant as a request of an illegal suspension and unfair investigation. any other release as the honorable court, deems just. Or say, court to nensha say, yes, I'm reinstating the Chief Justice. Court to nensha say process na beginning and fair ye betwam, near process a fair for na ye ni restaurant na office. And finally, or just 10 million, sir, I don't know me and a brand new soon sumase, any idea good animals in Ghana, eman $10 million. The ne ananopaya breaking news and said Justice Shams or Deputy Attorney General Betuni Facebook. Mamen Kaima was say the ECOWAS court has this morning dismissed Mrs. Justice Gertrude Torkono's application for interim measures. The court states that the application did not satisfy the criteria for a grant of interim measure. More particularly, the court held that the applicant's own conduct defeats her claim of imminent and irreparable harm. The court is therefore satisfied that the applicant has not demonstrated the existence of eminent or exceptional circumstances that will justify the urgency of the application filed almost 3 months after the acts complained of. Almost say, ye were the April. So we bring sana harm bi or the other na file application in July, April, May, June. July and a middle part of July. Into almost 3 months. No, so what didn't say, na Ghana ye be a tiada na would train 3 months and son ade conti omu jina sa ade ne so a. Maame no relieves a wo siki say ye ntwam na de no ye me ye to me koso ebe ha me no no. Mitwi die. That the court should step in because if they continue the interim process now, and as a suspension process now, as an investigative process now, the reputation ni ade no. On one demonstrating cha or chair answer no that's on the break court because of that 3 months window into on one demonstrating say ade no na agency be anima e be affecting the biasa. This is what Justice Shams says, and it's actually quoting to show that part is in quoted or say the applicant's own conduct defeats her claim of imminent and irreparable harm. The court is therefore satisfied that the applicant has not demonstrated the existence of imminent and exceptional circumstances. And also, Madam Gertrude Torkono couldn't demonstrate how urgent this application was. Into the way I was seek up, so you didn't say agent, or back court on one demonstrate this. This is what the court is saying, according to Justice Shams and quoting. Or say, in the light of the applicant's failure to meet the requirement of urgency, the court finds no basis for access the remaining criteria for provisional measures, same being cumulative. The request for provisional measures outlined by the applicant, same not substantiated, is therefore dismissed. It almost say when to meet the criteria for urgency, the court finds no basis to assess the remaining criteria for provisional measures. Now, simply sitting so story and I say, my main kind paragraph name just to be able to say the ECOWAS Court of Justice has dismissed former Chief Justice Gertrude Torkono's application seeking interim probation order to hold the work of the committee that investigated her removal from office. The court also rejected the preliminary objection from the government of Ghana, which argued that the original court had jurisdiction to hear the case. It almost say reject catch court in the massa. Your jurisdiction see a bit to case, We have jurisdiction to listen to the matter. But to say in its ruling on Wednesday 19th November 20, the ECOWAS court held that although the Chief Justice has established a prima facie case alleging human rights violation, she failed to demonstrate the urgency required for the court to issue temporary orders stopping the committee's hearing. And almost say those who demonstrated a prima facie both say they are and the fan would so I won't say same no urgency and so prove my court no it made the bedijuma a jinaso a granting the reliefs when to me improve this case or my rejected. That is the breaking news eba. 2. Madam said in Amtemakulo ye jeli no 10 years. Se maslo kokwa esika bi ekofa na nsase a yen hu akire ntu sha as far back as April 2024 and ye jeli no obeba maame na ama again almost say finding the guilty of misappropriating 1.7 million Ghana cedis. Sika na so de koma ma kantamantu eja ato na obeye timi afisika no we de court ajeli no ti we de ade a memfa leje dinka we court ajeli no court say wa physical no hwe evidence na wa fa and she was tried in absentia no ni ha because of the ho akawura baby kura don say otimi ko withdraw sika bi 500 million say loan from about Tampa savings and loans of ani nyina ene ajeli ni 10 years na manfo busa so obeba da ban na MPP ntime mfa na NDC na mosimu be yora de equitable mu mfa na mra na nkyerese mu ye serious mu be jeli obi a Attorney General kasa say no kan.
Office, that is the Office of the Attorney General, is awaiting the execution of our request to have her extradited to serve her prison sentence in Ghana. The International Cooperation Unit of the Attorney General's Department followed up on our request from the Department of Justice, the United States of the United States of America in September 2025. So if there is any impression being created that I am not taking any steps, this is the evidence that in September, that is just a month ago, I took the step of inquiring from the United States Justice Department the steps that they were taking in respect of the extradition. And they indicated that they are following their extradition procedures in executing the request, and that the fugitive would be extradited as soon as they have satisfied all the procedures. Thank you, Mr. Speaker.
Yes. Internet Madam said in am temakule hwenim so ono so oneko kanofra to mu nyina plane back omo beba. Na nura Attorney General call parliament na no. Ana minority chief bi honorable MP for Tolon Habib Kobisa kwese bail terms na yeye esoso dodo na esa Attorney General abem. Attorney General say senti na bail terms no dey bobo MPDC for MPP enko for ibeti 600 million 800 million ti esoso eni.
Thank you, Mr. Speaker. Mr. Speaker, I rise to ask the Attorney General and Minister for Justice the basis for the administrative decision by IOCO to demand justification as a bail condition for suspects in recent times, particularly appointees of the previous government.
Yes, Attorney General and Minister of Justice.
Thank you, Right Honorable Speaker. Mr. Speaker, in accordance with Article 14, Clause 4 of the Constitution, the EOCO and other law enforcement agencies are mandated to effect arrests and to release persons who have been arrested either unconditionally or upon reasonable conditions necessary to ensure that the accused persons or the suspects appear at a later date to stand trial. The justification for bail conditions, even if on an administrative basis, in the recent cases is not new, and there is no intent on the part of the EOCO and the Office of the Attorney General and Minister of Justice to impose arbitrary bail conditions on government appointees of the previous government. The grant of bail with adequate justification ensures that suspects will attend court when they are needed to stand trial. Mr. Speaker, this is my answer to the first question.
Honourable Member, any supplementary question?
Mr. Speaker, I would like to find out from the Attorney General and Minister for Justice whether he thinks that the bail conditions currently done by IOCO, we think it's the right way that bills should be set for any Ghanaian, not necessarily people in the political class.
Yes, Honourable Minister.
Mr. Speaker, I have already made it abundantly clear that the Economic and Organized Crime Office and other law enforcement agencies under my ministry are not acting arbitrarily. Bail depends on the crime, the gravity of the crime. And so what we are seeing now is that the sums involved in the criminal investigations are very huge. And because they are very huge, if you set very low bail conditions in terms of the sums, the likelihood is that when the person, the suspect, escapes or is unavailable to stand trial, whatever you are able to extort in justification will not be able to offset the sum that is involved, the criminal liability that is involved. So, for instance, if you have a situation where the suspect is accused of, let's say, causing financial loss to the state in the sum of 1 billion Ghana cedis, or stealing in the sum of 31.1 million Ghana cedis. You cannot set bail terms that are, unjustifiably low. So it is the magnitude of the offenses we are dealing with that dictates that we set bail sums that reasonably justify the crimes that have been committed or alleged to have been committed.
Any further question?
Yes, Mr. Speaker. Attorney General and Minister for Justice. My little reading. Bail. Conditions. Will you consider other form of conditions for granting bail to former appointees if you reasonably believe that the person will be available when needed? Because I might be wrong, but my thinking is that bail is set out in many cases so that the person can still be available, or maybe the person will not run away. After taking the passport of the person, but asking for landed property, justifiable surety.
Honorable member, you are violating Standing Order 88.
But Mr. Speaker, so my question, will you consider other form of bail conditions rather than this current form IOCO is implementing?
Yes, Honorable Minister.
Right, Honorable Speaker. The Minority Chief Whip is asking me about other forms of bail conditions. As a lawyer, I have been trained to do what is traditionally and legally acceptable before the courts of law. So bail sums, usually bail conditions are either tied to the sums of money to be justified by landed property and so on and so forth. And we haven't done anything that is out of the ordinary.
Yes. So that is the submission of also the Attorney General. So on drain say eso. You can say or drain say case na form hunu sika na ededa no ni mu odu. Entina omo bail condition also and of all these three issues